Good evening. This is a regularly scheduled public meeting of the Zoning Board of Appeals. There is an agenda posted on the door. We're going to follow matters in the order of their agenda. We ask that if you've got a cell phone, if you could please put it on mute. Oh, is Channel 79 recording?
Yeah, there are, but.
Sorry, Channel 79, we're starting here. We'll have public hearings. We'll allow everybody time to speak at those parts of the hearings. We will also, if we close your matter, we may deliberate tonight. During the deliberations, we cannot accept any further input. If you want to stay for that, you're more than welcome to. If you don't, you can contact Woody tomorrow, and he can tell you what was decided on your matter. Without anything further, I think we will go ahead and get the hearing started. We have one continuation, calendar number 9/2019, Mill River Financial LLC. That will be continued to our June 12th hearing. There was an issue with neighbor notifications, Woody?
Yeah, a couple other plan changes too, evidently.
Okay. So if you're here for that hearing, that will be continued.
That's at 18 Charles Street.
18 Charles Street, yes. We're going to open the hearings with calendar number 6/2019, the application of Wilder Gleason for 1 Tokenie Beach Drive. Wilder, I will mention we do have a timer. We try and keep the presentations to 10 minutes. We've seen this application before, so what we'd like you to stick to is what the changes are. We sort of sent you back with some requests. I think there was sort of a list of what we wanted to see.
Right.
So if we could try and stick to those, not limiting you to 10 minutes, but we'd like to be mindful of that.
You raised a couple of substantive legal issues. I submitted a 4-page memo with 95 pages of exhibits, which I'd like to at least be able to highlight for you.
Sure.
And we have a lot of changes.
Okay.
So Mancini's are here. I've got Doug DeVesta, our engineer, and Jay Valade and Kelsey Brennan from Mark Finley Architects are with us. There have been, at the last time, you expressed skepticism about the pool variance. So, and then board members requested information on the status of the septic system and the feasibility of moving it, and information on the volume increase of what we were then calling the bonus room, but more accurately is a children's recreation and study room, which is over the garages with a connector from the 1-car garage to the 2-car garage that houses the children's study room and recreation room. That's a more accurate nomenclature of the use. Bonus implies you don't really need it, and I don't think that's accurate. We'd like to be more precise. So there were some questions also that claims that we were expanding a non-conforming use possibly, and that the application could not be approved because there's no new hardship since the Castleau application, which happened earlier this year, and in light of the finding in Castleau that that was the maximum reasonable use, the minimum adjustment necessary to allow reasonable use of the property, you don't have authority to approve this application under case law and under that finding in Castleau. And I submitted numerous applications where you have made subsequent variances for the same property that previously had.
Within 2 months of the original?
Not within 2 months.
No.
6
Okay.
months you do.
6
months, yep.
You've submitted?
Yep, there's one there.
Which one?
It's the one that was, I believe it was a Bob Maslin application on Juniper Lane, and it was originally for Corinne. Let me just see. It's exhibit. It's Exhibit I, McKee, which was calendar 4/2016, and then subsequent prior calendar 17/2012. I'm sorry. It wasn't 6 months there. I'm sorry. It was 2 years. It was
What were they? 2 years?
2 years.
And my guess is, without going through all the case law, cases have changed, the state of Connecticut's law with regard to variances has changed dramatically.
It changed in 2013 with the Varillo case.
Yep, and the cases that follow kind of provided further definition of what the limitations were on the board.
Right. I researched to, okay,
You're going to have to present why you think what was minimal adjustment necessary last time should be expanded,
okay.
other than just pure personal desire of the contract owners.
Okay.
Which case law suggests is not the basis of a variance.
Okay. I'll go through the memo, and we'll go, okay, if I can.
No, we've read the memo,
All right,
so please don't read the memo to us.
okay.
You can highlight important things.
All right, so let me just go through. First, we have decided to withdraw the application for variances for the pool. And I have revised plans that show, this we just got today, so the pool variance is off the table. Mancini's have asked their pool designer to, and I have extra copies waiting for you, full size, 2 full size. There should be enough copies for everybody.
Did you submit this before then?
No, we just got these today.
Is there anything different?
Yes. So if you look at the highlighted version, which is the smaller version, the pool now meets the setbacks, which are colored in orange.
Great.
And the pool equipment has been located into the buildable area. So we've made a major change.
Great.
And the pool is off the table, so now all we're looking at is the variances for what we've been calling the Mancini house changes. We also submitted a letter from Doug DeVesta confirming that the septic system really shouldn't be moved and needs to be kept where it is. And we've modified the house plans in major respects to reduce the volume within the area. The ridge of the, let's see. So this is the survey that goes with the property. It's the latest one, and it's reflecting the changes before we move the pool equipment into a conforming location. I have copies for everyone with 2 full-size for Woody, because you'd like to have the full-size copies for the file, right, Woody?
Nice.
Okay. So there's copies here for everyone. Okay. So in this, calling out.
Plenty of them.
So here's, the pool is here, the pool equipment, which was located here, is now here. And we're showing the 5th bedroom, which is within the existing building footprint. And that would be an amendment to the plans to allow that. There's no change in the exterior envelope. And the expansion, vertical expansion over approved footprint is called out in pink.
So
That's
go
what
back to the hash mark where you say that's the 5th bedroom.
Yes.
Are you expanding what was approved
No.
previously on that?
We are,
Or is that just where you're adding the?
there's an existing 2-story space
Right,
that's
so-
a living room.
so
And
you
we're
are-
just putting a
so
second story.
There's no addition there.
There's no
Right,
addition.
so just can you focus on where you're expanding what was previously approved?
There's no expansion, it's, yeah.
And on the property, where are you expanding
The
what
only
was
place is
previously?
here.
Okay, so
So
walk us
focus
through
on
that.
Okay, so on that, and I think what we ought to do is, I think we ought to ask Jay Valade, our architect, to take you through that expansion and what's going on. Jay, you probably ought to come over here so you can use the microphone, please.
Oh. Right, yours? Need that.
That hurt her ears.
I'm sorry.
Want to check it and make sure it's okay?
Go ahead.
Is it working?
Jay
okay?
Valade from Mark Finlay Architects. What I'm going to show you, Kelsey is going to point out for me. Above the existing footprint of the garage, it's a 3-car garage, and what we've added was a rec room above the 2-car portion, and then we added a new stair towards the back of the 3rd car bay, and kind of we're calling it the connector, so that you have the head height to get into the space above the two-car garage. What we had previously shown was a raising of the roof volume. The dotted line here is the approved. The dotted line here was what we came in with last time, and in between is the new volume. So we're basically raising the roof of the two-car garage by about 1'5". The connector piece above the one-car garage, we're raising by 3 feet. And then the reason that we're doing that is so that we have the head height inside that roof to get up the stair and into the space above the garage.
So when they approved the prior approval, how did you get into that space?
We didn't. It was not usable space. It was just attic space from
Above the garage?
Above the
Drop
garage.
down above the garage, drop down storage above the garage?
basically. Correct. So what we want to do is take advantage of that, but not change the volume considerably, but just raise it up by a 1'5", so we could access that space and use it.
And how much of that, the walkway, where, is that in the buildable area, is that not in the buildable area?
All of it is above the existing footprint that was
That's not my
previously-
question.
Okay,
Is it additional volume outside the buildable area?
correct, yes, it is. So,
All of it?
Wait, Mark, it looked like before it was 700 square feet of space. You guys cut this back
we
to
cut it
roughly
back because when we
450?
lowered the roof, when you lower the roof, you have less usable space.
Developed space,
upstairs.
okay. So you did reduce by about 147 square feet, but it's
In-
still
in-
not, to
in
Gary's
round
point, in the
numbers.
buildable area.
Correct. So
Okay.
when, if the drawing down below that Kelsey's pointing at of the plan shows our 25-foot setback, which was approved, the 40-foot setback, which is what is the allowable, and the space between shows you what is volume that we're increasing. Basically, the top portion that's within the setback of 40, between 40 and 25, is about 57%.
Is it possible
this
to
room.
make that connector somehow inside the buildable area?
Not within the footprint that's already there.
But
because
you have more room inside the buildable area. Can you make that connector inside the buildable area?
No, because there's the garage right there, and so I can't really put that connector, if you go to the first floor plan. So right now, this is our third car bay,
Yeah.
and so we're putting the stair up
But
here.
why can't you? How high is the third floor? Because on that drawing, through for the footprint, if you drew, it's kind of halfway through the bays of the garage is where the setback line is.
Correct.
So you can't, there's no way you can put the connector,
Well, if the
That way?
connector was here,
Yeah, for
it would
example.
interrupt the garage, and I couldn't use that garage.
because it's not high enough?
It's
What
not
part?
high enough. So basically, here's our building section, it's right here,
Yeah.
right here, and over here as well. So this is, I'm pulling into the garage, the stairs are across the back, the floor is here. If
think-
I were to put the stair
Excuse
anywhere.
me, sorry, can you pull that forward so all the board members
Yeah,
can
It's
see?
I
really,
can't
it's
see
really
that.
not, it's not where the connector is, but it's where the stairway is.
It's where the stair needs to go in order to have it
So you
maintain
can't
the
connect
garage.
it, you can't connect it from without a stairs and go from the second floor of the house? Like many bonus rooms are accessible from?
Again, it would be the same scenario where I need the height to get through there.
But you can build more height in the setback, in the buildable area.
Mark, what about a spiral staircase? Was that a consideration?
We didn't look at a spiral staircase, but it's this connector piece that runs
It's the height of it.
across
It's
that.
It's the height that's the
So you
issue.
can't,
It's not really the location of the stairwell, it's the height of the bridge that you need to be able to actually use it as functioning
Be able
space.
to get it.
so you can't connect it without a stairway from the second floor of the home.
Without interrupting the two bedrooms that are already there.
Yeah, but these are choices that you're making.
Understood.
You're choosing to build a bonus room that hasn't been approved. So we're just asking, are there other options that would be more conforming with the regulations than the one you're proposing?
To try to get a two-story, a connector through here.
Yeah, I'm not an architect, I'm
Potentially,
just asking one.
we did not examine that because we felt that this was the best in keeping with the architecture of the space that was there and would be less jarring from the outside to keep that center portion of the roof as the walk-through space. Basically, also, as you look at the elevations, So that's a 3-foot differential, the 1.5-foot differential. We're still 8 feet lower than the main roof of the main house, which is primarily within that setback as well. So what we're doing is we're trying to keep it in a smaller scale and not overstep there as far as the volume is concerned.
The only other option probably is not to connect that bonus room, right?
Well, I
You
still
could-
got to get up there.
But you could, yeah, you'd have to do that from the lower garage bay
Yeah, so,
with a spiral staircase or something different.
but I'd still have to go out into the
Right,
garage to get
so it
up.
would not be
we're
connected
just-
to the rest of the house.
Right. Which
No, I
is-
get it, I'm just wondering,
Yeah.
okay.
Okay.
And as this exists now, this is now a 5-bedroom home with the bonus room, whatever we're calling it.
The rec room.
The kids' rec room, okay?
And then the
That's
infill-
Sorry, you're calling the rec room bonus room is the one above the garage?
Correct.
You're proposing to do?
Yes,
Right.
the proposal.
And the 5th bedroom is now, instead of a lofted living room, you've now made a bedroom there.
Correct.
Okay,
Correct. We've just filled in the
Yeah,
existing
but that's
double
in
height
keeping
space.
with,
that's fine, that's
that's in
within
keeping with
the,
the volume, whether
agree.
we
Yeah, we
Should
don't
have
change the
allowed
outside.
that or not, but that's in keeping with the volume.
that was approved previously.
Correct.
Okay. Can you talk to me about the dormers?
The dormer on the garage side?
Yeah, I
Yes.
see 3 different sort of bluish dormer areas.
Okay.
Or am I misreading your plans?
Yeah, the original, there was no dormer on the garage.
Mhm.
The previous submission where we had the higher roof, we had a thinner dormer.
Mhm.
And then when we lowered the roof down in order to get head height around the room more, we widened the dormer on the garage side from 16 feet to 20 feet. So we could still have usable space.
Creating a little bit more volume.
Creating a little bit more volume on the width, but we lowered the height.
And roughly half of that is within the setback area?
We're in the
57%, you said, yeah, okay.
43.
But not
And
where
the-
the dormers are. The dormers are, I'm sorry,
Go back to that
all of the
plan.
dormers are in the setback.
Well, again, it's about the same proportion.
Oh, it draws through the middle
Yeah,
of the
it's right through
dormers.
the middle of the dormer.
Got it, thank you.
And then what's the dormer on the east elevation?
The dormer on the east elevation is right at the top of the stair, so I have the head height to get up there. So when I get to the top of the stair, I'm inside that dormer, and then I walk straight forward. And on either side, lower, is a 5-foot gable. So I would hit my head if I didn't have the dormer to get up inside.
And so what, I mean, I can't tell from this, what are the actual ceiling heights in this space?
So in the connector, what we've got is a 7'10" ceiling height. When I come up to the top of the stair, I have basically about a 7 foot right at the outside where the dormer is, and then it slopes up a little bit, so I get to a 7'10" ceiling that I walk through into the rec room where the ceiling height is, again, about a 7'10", 8-foot ceiling inside that zone with a 7'10" at the head of that dormer. So,
It's pretty modest.
yes. We had more, but we were trying to keep it down.
Okay.
Can you tell me with the addition of the 5th bedroom, but without the bonus room, what's the square footage of the home?
All right. The previous approved was 5190, and we added 332 for the 5th bedroom, so it would be
55-ish.
5,500.
And then what's the size? So 5,500.
5,500, and then the bonus room, or the rec room overall is about 630 or 610.
553.
Oh, including the connector.
Including the connector.
Yeah. So our overall is
We're
about
talking plus 6,000. 6,000 plus.
6,160. So we're about 950 square feet additional.
Okay.
I think I understand the application. Dan, do you have any questions? Barb?
One last question, how much of the rec room is in the non-buildable area?
About 57%.
You keep saying that, I'm sorry.
Yeah. All right.
57% of the 553 square feet, not the 700, because you scaled it back now.
Yes.
Okay.
Ruth, any questions?
Any other questions?
Gary?
No, I'm good. Thank you.
Woody?
Okay.
I do have a question. It had to do with the use of this and whether there's any concern on the part of the board. This certainly looks like what we see often is a potential nanny space. It has a storage room in it that commonly becomes a bathroom. Does it matter what the use of it is? If so, you would need to say.
Yeah, I think.
What's the septic rated for? How many bedrooms?
5.
5 bedrooms?
5.
The septic
Yeah.
I'm
If
not,
we were to approve it, we would not allow a bathroom in there, correct?
That would,
well, bedrooms
The
drive
septic
septic.
system needs to be
not
expanded as
No,
is.
but bedroom, right, but we wouldn't make it a
Right.
bedroom, not a bath, right.
but they're
No, no,
going
we're
to.
going to approve, Woody, we would approve, if we approved, we would approve the application as presented with the uses that they're presenting.
But I would call out specifically no bathroom in there.
yeah,
Right,
that
we're not
would be
proposing
fine.
it.
But it's
That would
common,
be
we
fine.
get application 5, 10, 20 years later to convert interior space.
Right.
So
No, I think we would
we
have
would
to
be
do
fine with the
that.
stipulation, no bathroom. I wanted to check with John and Catherine, and they've said that it's
Not being
important to
affected.
them. They really don't want to make any change there, so that stip would be perfectly acceptable.
Okay. Any other questions from the board?
No, I would like to say thank you for finding a way to pull the pool, which was problematic in our last application, pulling it into the buildable area.
We've really worked hard to try and
Yeah. No, that's
present you with the
appreciated.
minimum. And I'd like Doug to address, because there were questions about the septic, and I would like him, are you guys okay with that?
Yeah, it's not
Because
necessary. His letter is.
we can't move that septic,
Yep.
it's where it belongs. And
I think the question, Wilder, from the last presentation was whether the septic was actually installed, and it's been confirmed that it was installed in 2000. So
Right.
there was no, beyond that,
Okay.
we're satisfied.
All right.
As long as it's there and existing and functioning.
It is
The-
functioning. I don't know if
The concern
you-
was if it wasn't installed and we were proposing it, then we should be looking at alternatives. But-
we
but that's
have
not the
a
case.
letter from Ralph Palladino saying the system is functional. If
Great.
you want me to submit it, I'm happy to, but I can represent it is, based on that.
I think that's more than sufficient.
And I believe we submitted as part of the memo, the letters of support from the neighbors. So this is not a case where you're going to have a neighbor appeal.
Great.
It's something that is, the neighbors have signed off on the original plans. They would be happy with what we're presenting tonight. The hardships are what were talked about in the memo. In fairness, there really isn't any substantial change. It's the same as what it was before. But in the memo, I identified a number of applications where, after the Verillo case in 2013, you approved an application on Richmond, the most relevant one. And I'd like to just walk you through that. There's the history of this property itself, which got a variance in 1971 to put a living room immediately adjacent, 18 feet away from the Goodnow property. It was about 7 feet forward where we're proposing it now, but it was 7 feet closer. 13 years later, Judge Dean and his wife, having gotten that variance, came back and got a variance to install a 3-car garage with a family room above it, 25 feet from the Tokenique property line. So it's essentially the same application that we're asking for now, was approved in 1984, 13 years after a prior variance had been granted. Now, at that time, the case law wasn't as strong as what it is today.
Right.
However, the Tokenique Club, which I've represented since 2003, has had numerous variances. And in Exhibit C of my memo, there's a number, 2014, 2015, one for the bathhouse, where we said we're going to pull the bathhouse further away and reduce it, and then the club said, wait a sec, we don't want to do that, and we're going to keep the original wall of the bathhouse, and we came back within 6 months, within 6 months, that was 6 months, and got a subsequent variance, and that was in 2015. And there was no change in hardships then. We had nothing that changed. We were going to shrink the bathhouse, and then we came back and said, oh no, we'd like to make it bigger, got an approval. And some of you guys sat on that panel, I believe, at least one of them. I don't think you were there then. But, so That was the one that was 6 months, Gary.
Okay.
And then I go back to I actually did research to see if I could find a case that interpreted Virillo and E&F and the other recent appellate court cases in the draconian way that you suggest needs to apply to this application. And I couldn't find one. That case doesn't exist as far as I know. So what do I turn to? I turn to the other precedents that I cited in the memo. You've got Dean in 71 and 84. You got the Tokenique Club in 2014. It's the bathhouse, 2014, both in 2014, I believe. That's Exhibit C in the memo. Then there's 21 Park Lane, Olson, calendar 10, 2017, which approved a substantial two-story addition to a house that got a variance in 1984. 2017, Virillo had been decided for 3 years. The prior variance was for a second-story addition and two-story addition in 1984. That was the minimum necessary. Here you've got, and by the way, the Tokenique Club resolutions, there were statements. This is the minimum adjustment necessary to allow substantial use of the property. Those 2015.
The original one.
Yeah, the 2014 and 15.
So shame on us.
Well, I'm just saying, I wouldn't say shame on you. I'd say that what you've done is you've done what I think is appropriate to say, look, would we have granted this variance if it had been the initial variance? And is it appropriate for someone to have the use that they're proposing here? Are we going to penalize the Tokenique Club because they said we can shrink this and they said 6 months later, no, we really can't? Are you going to penalize the Vancinis because they didn't come in with the first application and the Castellos are empty nesters and don't need a recreation and study room for their kids?
Need.
Well, the typical.
But the law is, to
Needs
deny
and
the
drive-
substantial benefit of the land.
All right, so the typical house on 1 acre in Tokenique is likely to have a recreation and study room for the kids. I would think that that's a fairly common occurrence.
All right,
And-
Wilder, I think we understand your positions
Right, but
on
let me
this.
just add one more, which I think is the most compelling, and I did highlight it in the memo, which is the Wolfric application on 15 Raymond Heights. And that's one where, in calendar 31, 2014, I represented neighbors opposed to this. And a two-story addition and addition over an existing first story were approved by this board. And then 2 years later, Jacek Begazinski came in calendar 13, 2016, 2 years later. And by the way, the initial resolution in the 2014 said this is the minimum adjustment necessary. And then in 2016, you guys approved a second-story addition over the existing first floor, just like us, and again found it was the minimum adjustment necessary. So your own acts show that you haven't interpreted the current case law as has been suggested it should be. And there is an appellate court case that says courts are not to substitute their judgment for that of the board, and decisions of local boards are to be upheld as long as honest judgment has been reasonably and fairly made after a full hearing. And I would submit that you have the power to grant this variance, and that despite the draconian interpretation that's been suggested, I just don't know why this board would conscribe its power if someone came in initially and said, I want a great big house, and you gave them the variance, and then they came in, or in the case like this, I want a house with a children's rec room, and then if you approve it initially, and then just because of circumstances, the first person who comes in says, I don't need it. Is that really how the law should read? Is that fair? Is that appropriate? Is that just? Is it equitable? You're here to do equity in the application of the regulations. And if you would have approved this initially as part of the Caslow application, you should approve it now.
Thank you very much. With all of that, we'll ask, are you finished? Okay. Is there anyone in the audience that wishes to be heard on this application? Okay, seeing no one, I'm going to go ahead and close the application. Thank you very much for your time. Oy. Okay. The next item on the list is calendar number 7, 2019. This is the application of Chris No. Woody, we've had some conversations about this application, and it is my interpretation that it is not properly in front of this board. The variance that he's seeking was previously granted. The portion of his property that he is seeking to do work on is subject to that variance, and that variance is still valid. He built what he had applied for. I will note that there are some issues with this property, and that as part of moving forward with the building permitting process, that Mr. No needs to comply with the regulations of the town of Darien. And if he's not going to comply with the regulations of the town of Darien, he can't move forward with his project. But that's really an enforcement issue. That's not a zoning variance issue. So I think for that piece of his application, he has a valid existing variance, and he should proceed to the permitting process if he wants to move forward with that. As far as the subdivision application, again, we had conversations with town council, and we were advised that subdivision applications are the sole authority of the Planning and Zoning Commission. So if he wants to proceed with a subdivision application, that would be properly made in the Planning and Zoning Commission, not through the ZBA, in that it's pretty clear from the zoning regulations that a subdivision that does not conform with the zoning regulations is unlikely to be granted. So he can proceed with that application how he decides. I'll also note that we had a few other issues with this application. The application wasn't complete, maps weren't submitted, things of that nature. So in the future, before we see applications of this nature, they really need to be complete. And finally, the applicant didn't pay the application fee. And there was a question as to whether there's some sort of equitable measure that needs to be taken when the town is requiring that he follow a set of applications. Well, no, there's not an issue there. If he's going to make applications to the town boards, whether it be permitting applications, whether it be zoning variance applications to the Zoning Board of Appeals, or subdivision applications to the Planning and Zoning Commission, he needs to pay the fees like everyone else before he gets heard. It's really, if you look at the equity and the fairness of it, he shouldn't be granted some privilege that every other applicant has to follow through with. So for those reasons, we are not going to hear the no hearing any further. I don't think that there's even a motion to close it, or it's just not properly in front of this board. Is there anything you'd like to add to that, Woody?
Well, I guess the question is, have you reopened the hearing, or it sounds like you're saying no?
I think what we've decided,
But you want to
and I don't want to
ask,
put word in, I think what we've decided is the application shouldn't be before us.
Yeah, we're not reopening.
It's being dismissed.
at this point, it's simply incomplete.
No, it's being dismissed.
Okay.
It's not that correct me if I'm wrong, Mike, you're not saying that the materials are incomplete, it's just that it is not properly before us, so it's being dismissed.
Correct.
We're not asking him to come back with more materials. If he wants to build what was approved previously, he should submit a permit application to the building department. And the building department should consider issuing it in light of the other violations that may be on the property.
Okay, well, that would go to both zoning and building to get a construction permit.
That's fine.
Yep.
That's a routine process.
And
What
so
you're
there-
saying is,
That's not
revising-
ZBA.
You're advising that the violations, what, should be addressed or
I
looked
think
at?
that's the zoning, the zoning enforcement officer's role is to look at those as part of any application, isn't it?
I mean, would you permit an application if there's all kinds of violations on the property? You know what I mean? Let's say this wasn't in front of us at all, and somebody comes in and they have lots of violations on their property. What would
It
happen?
Probably would be treated separately.
Yeah, so
Construction permit.
but I think our decision that, I think, what I'm hearing from the chair, which I agree with, is very narrow. That this is, the variance that was granted is valid. If he wants to rebuild what was destroyed in the fire, in accordance with the prior plans, he can do that. Provided that the building department issues the appropriate permits.
Yeah.
It's just not it's not required, no action from the ZBA is
Is
required.
And the same goes for the subdivision application.
But I don't even see that, to be honest, I don't see that noticed. The
It wasn't, no.
No, so
All right.
I
So-
don't think we addressed the subdivision application. If he chooses to make a subdivision application, the town should handle it the way it does every other subdivision
This
application.
is, I think we're giving this more
I agree.
deference than it needs. So this is dismissed. We're not going to hear it any further, and we're not going to make any speculations as to how we would rule, whether we would rule. You know, he's got to go through the permitting process through the town. Okay, next on our agenda is calendar number 8, 2019. The application of Lance Zimmerman, Zimmerman Architects, on behalf of Marie Gallagher. This is for 21 Norotan Avenue.
Good evening, Lance Zimmerman, representing Marie Gallagher, 241 Norotan Avenue. You saw this exactly a year ago, approved it, it expired, and we're back. It's exactly the same proposal. It's a non-conforming lot. It's 50 feet wide instead of the 80-foot width. It's very small, 8,000 square feet instead of the 12 that's required. We went through looked at all the neighbors. It's never been subdivided or owned by anybody, next to it. So.
Lance, did you and your client consider seeking an extension of the deadline?
Missed it entirely.
Well, that's it. So that's just, it was an oversight.
I had even filed the building permit.
Right.
So
So
I
had-
had no
I think it's
idea.
important to know that had you asked.
Oh, I know. I've done it
administratively, we
before.
generally extend them.
I've done it many times, got an extension, but I filed for the building permit. I thought the house was down and they were underway. And then I get a call from the building department and they said they never picked up the building permit. And they haven't demoed the house.
Okay.
So it's, it was just an oversight on everybody's
Can we
site.
incorporate the prior record by reference? Or
I
do,
think we should.
yeah.
I think that's the way to make it tightest, instead of trying to recreate it and missing something.
Right, okay. So
That-
we're going
I
to
agree.
incorporate the entire previous application, the record from that application, into your current application and presentation. Note for the record, we did find that there was a hardship, and we did find that, was I on this? I was not, but Dan and Barb were. And we did find that there was a hardship. We found that this was the minimum adjustment necessary. And
Excuse me, Mr. Zimmerman, did you explain it's a lot width?
yeah, he did.
Thank you.
And he's applying for the same variances that were applied for before. So
And the
all-
determination, yes.
all of that will be noted in the record. I don't think that we necessarily have to read anything into the record.
No, I just want confirmation in this record that the plans are identical. to what was-
Absolutely, haven't changed a thing.
Okay, thank you.
They are exactly the same, and it's going to get filed for building permit
Thank you.
exactly that way.
Okay.
Got it.
we would encourage you to do that expeditiously
Oh.
and move through the
I
process.
told them they should have their demolition done already, so I hope they do.
Thank you.
Thank you very much.
Thank you.
Is there anybody that would wish to be heard further on this application? Please step up to the podium and give us your name.
Hi, I'm Kim McDonald. I live on Edgerton Court, and the neighbors all got letters that you're building. We're really happy that, something new is going to go in there. But we all have major, and I didn't know that this was already approved. I'm not sure if the other neighbors knew that either. Our concern is just the water issue on Edgerton Court. There's severe damage as it is on the street in our basements. The street has potholes everywhere. We're just concerned with the size of the building and if there's going to be sufficient
Sure.
water control.
Sure. That's a great question. So projects like this are required to maintain their stormwater runoff on site. And Woody, did they submit a drainage report as part of their
Yeah, I
application?
think it's right there. Maybe Mr. Zimmerman can actually.
Oh, sure.
Yes, it is. This is the drainage plan right here.
Okay.
And those are the Cultex that are done by the engineer.
Okay.
So yes, that is all
And that
part of the
gets-
submittal.
That gets reviewed by the town engineer as well?
You can specify that, but there is a routine that
Yeah.
they have to provide calculations and sort of stuff.
Yeah, there was a report and the plan and everything were turned in for the water.
Stipulate to the fact that it'll be reviewed by town.
Stipulate that
Town engineer.
has to confirm, okay.
They always do, but
Yeah,
that's,
so so you spent the time to come out here, so it's just, so you understand what we're talking about. Each of these projects is required to submit a drainage and stormwater management plan. They have done that with this project. It's actually the map that's in front of us currently. And then what we're gonna require, it's part of the process anyways, but we're gonna require that the town engineer review what their engineer has presented to make sure that stormwater plan actually does what it's supposed to do.
Okay. Great, thank you.
Thank you very much.
thank you.
Seeing no one further wishing to be heard, we'll go ahead and close your hearing. Okay, next on the agenda, the application of Lyle Fischel Architecture on behalf of Stephen Petrie and Patricia Murphy. We are looking at 6 Park Lane.
Yes. Hi, Lyle Fischel, architect, representing Stephen Petrie and Patrice Murphy. And so, go through some facts on the property. Built in 1928, we believe, for the Phillips employees, right? Long ago, and we all know Park Lane. It's a little street, one way, totally different zone than we're used to in this town. Purchased in 2004 by my clients, who purchased it with a finished attic. And
To be clear, purchased it in the current condition.
in the current condition, they haven't done a thing to it in their tenure at the property, right? I researched the building permit records. There isn't a building permit taken out on the property. So there's no way to judge when the work was done. When they bought the property, there was no discussion of any nonconformities. No one had any idea that this property, and it doesn't have any nonconformities except for the 64% half-story. The property is in a flood zone, so they could never do anything, any alteration or improvements in the basement. Matter of fact,
So how did this get flagged? Was it get flagged during a sale inspection?
bathroom repair. Bathroom repair that is up.
During the permit application for a bathroom repair?
Stephen, you'll have to answer that one for me.
Why don't you come up, if you don't mind?
So, there
You
was,
Just
have
give us
to-
your name for the.
my name is Stephen Petrie. Hi. There was a leak in the third floor bathroom, and it was.
Third floor
weird.
being this finished
Right.
attic,
Right,
We'll call it a half story.
okay.
but slightly more than half.
And as we were trying to find out, try to get some contractor to come work on it, all of these things started coming to fore, and we're just We've
I mean,
been-
wait, did someone do a calculation of the space in the context of the permit application?
No. This was supposed to, it was supposed to just be a repair, but that, when we were trying to find out about the repair, that's when we found out that this issue existed.
So this is all built, exists,
Right.
and it's been that way since we don't know when.
Since you bought it.
Since we don't know when.
When did you buy it?
Since Stephen bought
2004,
it.
right?
2004.
Is there
Well,
as a matter
probably
of law?
there's probably a lawsuit against the attorney that
I
represented
think you did,
them.
but,
I checked that now.
but what isn't there, is there some law or statute or a reg that if a non-permitted
Yeah, it becomes legally
Feature.
conforming.
Like a
after-
grandfather letter
Yeah,
or something?
isn't it 14 years?
Yeah.
Well, I don't believe it applies to this kind of interior alteration construction, but for the building of a new building, the placement of a shed, constructing foundations and all kinds of other stuff, there's a 3-year.
So
rule
really,
if
so
it's
you
not
could go
identical.
ahead, you could go ahead and build an
Sounds
addition
good.
to your building,
Yes, you're right.
hide it for 3 years and be okay, but not
Actually, I hear it's a-
14% more than you should in the.
I hear it's a
attic.
9-year letter now.
Yeah,
okay?
there's a
Is that what it
9-year.
is?
That I just got from the Stanford Building Department, and I tried to understand
So
it
is that,
exactly.
is it 9 year because it's city? Is that a Stanford rule or?
No, it's a
I
state.
think
It's
it's
a state?
I think it's a state mandate
Okay.
now. Yeah, so.
And they
So that would be,
don't, a lot of towns don't issue the 9-year letters anymore. It's just if it's beyond
It
9
is
years,
what it is.
it is what it is.
so couldn't we make them bring it up to code?
No,
No, that has nothing to do with us.
no. That would be a disaster.
And they have to rip all the walls out.
Right.
I
You
this-
mean, you mean
this
bring it
is-
up to code, you mean shrink the size,
No.
make it down to 50%? What do you mean to
While
code?
you're, yeah, no, I'm saying, make them fix the bathroom
Make
up to
it-
code, allow the,
Have you already fixed the bathroom?
No.
No, they're waiting on permits.
So
Well,
you're,
we
this
were-
is stalling the permit.
That was the beginning of it, was do we need a permit for bathroom repair?
Yeah.
Which is what started the whole thing. So for the
know.
last few years, we've had half of the floor torn up because, and no
Okay.
shower.
I
But
think I
let me just
understand the
ask
situation.
from, is it remotely possible to bring it down to 50, to fix the nonconformity? Just, someone needs to answer on the record, not from the,
Someone would need to tear out walls. And, you know, it's up in the attic, so,
and you get there via a regular staircase, not
Regular
a drop down,
staircase,
right?
yeah.
Obviously.
so the,
Sorry, you have to speak from the podium. The microphone only picks up so far.
Yeah. Well, if you notice there, I did a cross-section of the attic space, and you can see very limited space. I mean, it goes right down to 0 headroom and right up to 11'3" headroom. So realistically,
Yeah.
this is, most of it's not usable space, you know, and they have moved into this space and made it their own, but, you know, it's, as far as habitable by state code, we're not even near that, okay?
So Woody, what the applicant is asking us to do is grant a variance that's basically accepting what was done prior to 2004 and making it
grandfathering.
grandfathering it, so now, so then it would become legally non-conforming, but it would be legally non-conforming, as opposed to how, when it was built illegally non-conforming.
Yeah, well, we presume, because we don't know what the codes were back then, and maybe it was legal back then, so.
But no, because I think the 50% rule was,
Always.
predated that construction.
Okay, all right, did not know.
And Mr. Fischel, can you tell us how big the house is in total? The square footage, do you know?
Total square footage, once again, I'm gonna have to ask. Yeah.
You have to say who you are for the record,
My name's
please.
Patrice Murphy. So I think it's 1650 or 1680 total square feet. And the house was actually built 1895 and it was moved to the current property
Cool.
and put on a more recent concrete foundation in 1920. So when we talk about when it was constructed, it wasn't constructed in the 20s, it was constructed in
Wow.
1895. So
They changed the river.
Patrice, what is going on the lower level? Is that also finished?
the basement?
Yes.
No, not at all.
at
It's
all.
just got concrete floor,
Working
concrete
cellar.
walls, open ceiling.
Okay.
We just have the laundry and storage down there.
Do you actively use the third level?
Yes, we use it as our master bedroom.
Okay.
And it's got this little bathroom that, as we say, is half demoed at the moment.
Okay.
And just to sort of give you the picture of what Laura was describing in terms of the way it's finished, the slope of the roof all the way down to the, where it's that
The knee wall, yeah.
that deep, and it's just like shelves that are, to about, I don't know what that would be, 4 feet, 4.5 feet or something. And, they could have as easily not finished it all the way back, but they did. I don't know why. But that's why one of the reasons it counts, because we've got to count all of that because it's carpeted and sheetrock all the way down.
Yeah.
So we'd have to bring it to 50%. We'd basically have to tear out carpet, tear out sheetrock. I mean, we're just trying to avoid having to tear stuff out.
Yeah.
So you're
Okay.
actually saying that the storage area under these eaves is counting as finished space when really it's not, it's storage area.
Yeah, I mean, we shove
It's
boxes
just
in there.
carpeted, so
Yeah.
technically it's finished, okay.
yeah.
So of that 516 square feet, would you guess 140 of it is this, like what area would you say is tucked under the eaves?
That's a good question. I didn't really get in under the eaves. It was difficult to get down there, so, but I could figure that out if required.
Excuse me. But the quantity that you came up with is the finished carpeted floor area.
That's
Not
everything.
the storage niches underneath the roof.
That's everything to the walls that have the closet doors on them,
Yeah.
okay?
So that is usable, habitable space.
Yeah, which are, I think one of them's 5'1", the other one's 3'6", I mean, they're very,
They're habitable by hobbits.
Yeah.
habitable, yes, exactly.
Okay.
Yeah, kids would.
Now, we have, we sent out our notices to all the neighbors, 8 neighbors. We have 5 replies that are pro, and 3 no-shows, I guess. So if you want to pass the copies of the letters around, that would, we say that we've done our due diligence there, and,
All right. Anything further from the board? Woody, you want that for the record? Anything further from, Woody, anything further?
Not now, when we get to deliberation,
Okay.
to approve it.
I do want to point out that there were no other nonconformities. This is the only one we're trying to, see ourselves through here.
Okay, appreciate that. Is there anyone from the audience that wishes to be heard on this application? Okay, seeing no one, we'll go ahead and close the application. Thank you for your time tonight.
Thank you.
All righty, moving right along. This is the application of Mark LeBeau, William W. Seymour, on behalf of Nicholas and Jennifer Kalman, 8 Phillips Lane.
Good evening, everybody. Mark Lebo with William Seymour. I'm representing the owners and applicants, Jennifer and Nicholas Callan, who are both here with me tonight. Before we get into our presentation, I'd like to submit, which I've already given to Woody via email, but we have support letters from the 2 neighbors immediately abutting us on the sides and 2 neighbors across the street. So let me just hand these out.
No, thank you.
You asked for 7, so.
That's good. You need one?
No, I have the originals. Okay. Also, just so that you have it up front, I'm going to hand out reduced size copies of this exhibit here, just so that we can, as part of,
That exhibit goes to the alignment issue?
yes.
You left out all the ones that were proposed?
Oh, yeah.
Okay. Okay.
No, nobody voiced any opposition, so I think we're good there. So I just like, because it's part of our application, I wanted to touch on what's known as Section 372 of the zoning regulations, which speaks to the existing alignment of buildings. And this is important for a couple of reasons that I've outlined in the item K. Because back when these homes were built on Phillips Lane, it was the 1937 zoning regulations that were in effect at the time. For most of the time, the zoning, there was a new set of zoning regulations came out in 42. The homes were built primarily in 1940 and 41. So at that time, the chart in the zoning regulations had 2 columns in it for the front yard setback. One of them was titled Minimum Allowed, and it read, average setback line observed by buildings on the same side of street between 2 intersecting streets on the date of the passage of the regulations. The other column was titled Maximum Required, and at that time the maximum required was 30 feet. So, but when you read the definition of front yard setback, it read, where there is no existing building on either side of the street within the block, no new building shall be erected with its street wall, walls, or covered porches nearer the street line than the maximum depth of front yard shown for each respective zone in the schedule. So in effect, that made the so-called maximum required the minimum required. So it begs the question, how did all the houses on the south side of Phillips Lane get built generally 24.5 feet from the street line when there were no other houses to align any subsequent house with? So I would submit that in so much that the zoning regulations provide you with this tool that would purport to permit the Kalmans to do what they're proposing as of right, that's a tool, a valuable tool to use. It eliminates the need for any variance, and on that basis would eliminate any risk you might have of a variance approval being appealed.
Mark, I want to make a quick comment about that, because if I'm reading this right, it looks like it's all dormers. Every property that extends to that has these 2 dormers. And what you're talking about in your plan isn't a dormer, it's solid, right? You're going to get into the plans.
Well, we're going to, yes, because we're proposing a full second story.
Right.
Yes.
So that's the only thing. If I'm looking at this line, it looks like everything that extends beyond, because I see your point really clear. This is really helpful. They just look like dormers. It's not like a full wall, full second story.
Well, no, but the fronts of the houses are all at the solid line, and the dashed line is the setback line.
Yeah, but what you're arguing us, what you're suggesting that we adopt here is a 20, by granting this variance, essentially adopting a 24-foot front yard setback because the other houses seemingly have that.
Well, they have different types of dormers. This is a shed dormer that you're.
Not that we're
This is a full
proposing, no,
second
we're
story.
proposing
No,
a
they're doing
full
a
second
full
story.
second
Okay,
story.
And all the other
Full-
houses in my mind are story and a half with the, that's the only distinction I was making. Go ahead,
And they
Barry,
look
sorry.
like capes and this one looks
Primarily,
like a
yes.
colonial.
Yeah, so what, but again, what you're asking us to do is
It-
accept that, and then everyone else on the block can go do what you're doing. And it's establishing, by us granting this, would be establishing a whole new setback in this zone.
No, I would say that somebody would have to prove some sort of exceptional situation like we have here of how a house, if the zoning regulations when the homes were built required them to be at 30 feet, how did they get built at 24 and a half?
But again,
But
what you said, what
everybody-
you're saying is then we're basically rezoning it with a 24-foot setback.
I would say that it would be limited to only the homes, these several homes on
On
that
the
side of the
south side
street.
of the street. But again, but none of them, I think to Barb's point, none of them are kind of traditional two-story colonials. Is that correct?
Yes, for the most part, I'd say so, yeah.
And one, I think that was, Woody, where was this photo? Was this one that
That's-
has a step-back second floor?
Well,
That's the newer construction at
Few
the end
doors
of the
down
street.
it's on the opposite side.
It's on the opposite side.
Correct. And I'm not so certain that that was stepped back to avoid a variance situation.
But if you stepped your second floor back, you would avoid a variance situation.
We would, except that the complexities of doing something like that would basically put you at the threshold of saying, I'm going to tear this house down and build a new
So
house. In which case, I would have to wonder whether you would allow us to align the front of the new house with the other
What you would need to
homes.
do is do the same thing. What's the heart, is the only justification for accepting your application the alignment issue?
Oh, no, not at all.
Now,
I am
why don't you go
simply,
through-
I'm keeping the interpretation of section 372 totally separate and apart
From the variance.
from any proof of hardship.
So why don't you
or-
tell us the hardship?
I'm sorry?
Tell us the hardships.
Well, we have a number of hardships that were outlined in the item K. So it certainly changes to the zoning regulations and zone map since the lot was created and the home was built. At the time the lot was created, it conformed. The lot no longer conforms. We have ultimately what is a non-conforming location of the existing dwelling. We have, it's a non-conforming lot area and shape, and the architectural challenges that pose themselves, being the center chimney, most importantly, and then if the building were to be stepped back, then the stairway would need to be reconfigured as well. Never mind the structural challenges of having a non-bearing wall 5.5
In the middle
feet
of-
back from the front of the house. And it's important to note in this too, I believe, that in our design, we are 6.5 feet below the maximum building height.
How much did it increase the mass, the existing house? What are you adding to it?
As far as square footage?
Yeah.
Roughly, I think it comes out to about, including the little bump out in the back, I think we were adding about 400 and some odd square feet. I think
Okay.
the total additional living space on the second floor comprises approximately 405 square feet, of which 195 square feet lies within the front yard setback.
So almost 200 square feet is beyond that setback.
Right.
So that's your argument for extending the setback, because then if we line it up with everybody else, then we're really not outside of the setback, is your point?
Well, right, but I'm
Creating a
also
new
looking at the two things entirely separately. One saying that if you employ the tool that seems to be available to you in the zoning regulations, that being section 372, then no variance would be required. But if you don't agree with that in this particular and unique instance, then we're asking for the front yard variance of 24.5 feet in lieu of the required 30. And that's the
How much of the
only-
first floor is being retained?
All of it. The only thing that's going to be demoed
And the
here.
walls?
Walls, everything. Everything from the second story floor deck down will remain.
And you don't need to
Staircase staying?
rein-
Oh, sorry.
Yeah, you don't need to reinforce the second story floor deck?
I don't believe so. I mean, we've looked at certainly at the foundation was something that we were concerned about, particularly in the looking at the house, the right front where the screened porch is, because we know oftentimes that the foundations under those screened porches aren't quite the same. But the Calnans did some exploratory excavation. They dug down. There's a footing, full foundation wall, and the architect has represented that, no foundation work is going to be required in order to execute this plan.
Let me just stop you for a second. What's the purpose of section 372?
Well, you'd have to read the language of it and see what the.
Do we have a
was
copy
intended.
of section 372?
Well, I think in my staff questions, I at least copied a segment of it. Well, my understanding is that it's been intended to at least recognize those places where there's a pronounced rhythm of buildings relatively close together. There's a visual, structural, pronounced uniformity, it's called. I'm not sure it's normally applied to a street like this that has quite a bit of space around the houses, and trees and all the other. A row of capes, maybe even some of the
But
buildings.
what does 372 specifically say?
Oh.
Does it say we've got discretion? Does it say we can apply this rule? Does it say?
It doesn't,
that-
no, it's basically what it says is that planning and zoning staff can apply the rule and issue a building permit as of right.
Okay, and
We-
so.
we're only coming to you for an interpretation because I believe planning and zoning staff wants your blessing that,
But I
you
guess
know, and
question
my
would be-
understanding too, the way it's been explained to me, you would almost, from what my understanding is, that basically 372 doesn't apply anywhere. So it begs the question of.
Why is it there?
Why is it in there?
Right, so.
If it can't be used.
So, Mark, let me stop you for a second. So, Woody, is there, I mean, this is a little frustrating, because if there was a determination that 372 doesn't apply to this property, and you're appealing that, that's properly in front of us. But for us to interpret whether 372 applies to this, there's no determination. Like, we can't just speculatively do the zoning enforcement officer's jobs, right?
I agree, but also, I mean, even.
Like, we're not here to interpret or give our opinions on stuff, we're here to decide.
But
right?
don't we often ask you for interpretations of things when, and I think the section in the zoning regs regarding variances and appearances before the ZBA do give you the authority to be able to make those decisions when the planning and zoning staff doesn't feel comfortable.
Is that right?
Yeah, I think
Okay,
we have,
all right.
and we have done that.
I know we've done it,
But-
I'm just.
But the problem that section presents here is that it essentially would, should we make our decision based upon that, then we are essentially rezoning this, at least this strip of land, to have a 24-foot, haven't measured exactly, but that was your
Well,
number,
it's
roughly
24 and a half feet, yeah.
24 and a half foot front yard setback. And then that would permit every home left and right to build additional significant mass closer to the road than our colleagues at P and Z thought was appropriate.
Well, 16 got away with it by tearing down, pushing it back, and then
Correct.
adding the volume.
Well,
Okay.
Because that volume's not in the setback.
Right, it is
Could I
not.
just let me interject one thing? And I'd also like to leave that alone and say, on your exhibits here, and on this exhibit here, it is only these, what,
6
1, 2,
houses.
3, 4, 5, 6, 7, 14 homes that were part of the original Phillips Lane subdivision. So anything west of what you see on this exhibit
Including
is
16.
not, is including 16.
I saw that.
Is not part of this subdivision.
But
Let me ask you a question. The houses directly across the street, all of them, are they at the setback lines, the same distance from the setback, in the setback area?
Roughly, yes.
Now
But I don't think the alignment, if you were to take a straight edge and lay it on here, I don't think the alignment is quite as pronounced.
But are they at
But-
I'm sorry, I
but they
wasn't
don't
clear. Are
have
they
any
at 30
dormers.
feet?
They have straight, flat fronts, it looks like to me.
Some of them have
Well,
dormers.
Can I just address
Nick,
something?
I think Nick wants
Nick
to.
Calnan, owner. I just want to make clear, because we keep talking about, regardless of the rule, all the other houses on the street are not capes, not just with dormers. So directly across the street, it's full second floor.
But what set, are they
I didn't
24 feet, or they
measure it.
30
They
feet?
were-
That's what I'm asking.
They were,
That's what.
they're all one straight line across. I don't know if it's
Yeah, you
30 or
can see
24
it.
and a half.
That's kind of critical to us
But
deciding this.
is this just one side of the street to the other, the setbacks would be the same? Did you calculate that?
I think the homes on the other side of the street are more, I don't know if they comply, but they certainly appear to be more nearly compliant.
And they are not, my point is just that they are not just capes.
No.
But it-
And I would argue that 16 did not step back where their nearest setback is.
But if, what we don't know is, Mark said they're more compliant, perhaps they are compliant, perhaps they're not. But if they're two-story colonials on the other side of the street at 30 foot, they built those as a right. And my other, and so that is what it is.
A 3/4 wall, does that matter? I mean, again, I'm just trying to.
And
make the
it's
point
just
that we're not
volume,
all
it's
just
volume in the
capes.
setback. The other concern I have here, I understand it's an undersized lot, but it's not you've been here before, it's really unusual building envelopes. There's nothing really unusual about this building envelope. It is wide enough to sustain a house and comply with the 10 plus 15, and it's deep enough to sustain a house. So, you have a really significant building envelope. Have you considered making the additions to the living area that your clients desire within the building envelope?
Well, again, in order to get the second floor living space that they're looking for, they wouldn't get that if you stepped that back behind
No, but
the setback.
you are doing.
And as I said.
A portion of the house a portion of your proposal is a proposed one-story addition, right, in the back?
No,
What's that?
You're just going up. You could go back.
What's
You're
that?
adding a stone
Oh,
terrace.
we're removing this bay and just having a kitchen bump out, which is what, go back to, okay.
Yeah, Right, but what I'm saying is, you can do as of right. Is there other stuff you can do back there?
No, correct.
No, I.
We're already at coverage, and we're already taking some of the garage away and making it smaller.
So you're already at 20%.
Yes.
19.8%.
And
And
we're
I knew that
going,
coverage was not something that you guys normally would hear.
Yes, someone told you
Smart.
correctly.
So the only way to get the room you need in this house is to go up.
Straight up.
Okay.
But
Across the
can you
street.
can you get what you need through, so that it's not that imposing? The reason why we have setback rules, front yard setback rules, is to try to soften the imposition of mass close to the road. So on your side of the road, you have, it's seemingly from the aerial and from my recollection, mostly capes.
The first three are capes, yes.
Which
Then our
soften
house,
the-
which- And then the next house has a 3/4 second store, then we have two other dormers, and then 16, which is the massive new house.
Right.
well,
Which does
Which
step back.
is still at 24 front because they kept the front of the house.
Sorry, not to interrupt. I just pulled up 372 on my phone because I thought
Because you can.
because it was relevant. And it's it's a bright line test. I mean, the last sentence is, if on one side of the street within a given block and within 150 feet of any lot, there is a pronounced uniformity of alignment of the fronts of existing buildings and of the depths of front yards less than the depth specified in these regulations, a front yard shall be permitted in conjunction with any new building which shall conform as nearly as practical with those existing on adjacent lots.
Now, one of the issues, just so you know, is new building. What does that mean? We've interpreted that to mean a whole new house, a whole new structure that needs to be in alignment
No,
with the
that's-
others on the block. Not in
that's-
addition to.
No, that's
But-
crazy.
but
That
wait a
would-
second.
So they could do this if they knock their house down?
No, but you.
No, because then they'd be in the
wouldn't-
setback. They would push back.
No, but that's what he's saying. Then it would be new. So I agree with you, that's not determinative. But in keeping with so everything's in keeping. So what you're saying is that basically sets a new zoning line in disregarding the zoning,
Yeah.
and it allows you to build all the mass up?
Yeah.
I don't buy that, because that's not in keeping with that, with the.
Mark, can I ask you a
It doesn't say in
question?
keeping.
Across the
It's a-
street,
it's a-
It does say in keeping.
they're all in a line.
Well, not as,
Well, but
not
what I'm
quite-
saying is,
yeah.
can you
The front
apply the
yard shall
very
be
same
permitted in
things
each-
on this side that you have on that side? Are they set back the
last
same
sentence.
They're
amount?
more setbacks. These
I
houses
think
are all
they're, I
30.
think they're a little bit further back. I'm not certain, but
Visually, they
I
look like
believe
they're at the
those are a
30.
little bit further back.
Well, I
But
think the
what
road
I-
could be
getting
different than
back
what
to,
you think it is.
you know,
Mark, what, can you just show me where 150 feet of this property is? What,
well, each of these lots are roughly, let's say, 70 feet, 70 to 75 feet wide. I mean, our lot is,
it's a crazy regulation, it should be changed. But it's a regulation.
our lot is 75 and a half feet wide. So if you figure, you know, 2 lots either way, that would be 150 feet either side.
Yeah, so you're capturing,
So here's there, so we got these two, we're 8, so we got these 2 lots would be roughly, to here would be roughly 150, and this plus a little of that, because you see what had happened with this subdivision was, as you get further out towards Hoyt Street, the lots get shallower and shallower and shallower from Phillips Lane to their back. And again, I think Gary mentioned something about the mass and things like that. And again, I can't stress enough that we're keeping this house 6.5 feet below the maximum building height. And I think that more than offsets any sort of, you know.
so what
Yeah,
is,
this
how
talks about
how
the- this
high's your,
doesn't-
how high's your second, I figure it doesn't say anything about the second floor of the master.
Where they're basically two 8-foot floors.
And then what's the attic?
Well, there would be no real attic. I mean, if you look at the side elevations of the house,
Yeah.
you know, so we created in particular this one side section so that you could, you know, both the left and the right side elevation views with the existing and proposed elevation superimposed over the existing, so that you could better visualize what that volume is. You know, again, I'd like to, as long as we've brought up volume, I think it's important to note that, you know, volume, I think is, and bulk, is somewhat of a subjective thing. And in...
Or a mathematical calculation?
Well, it is, but in Darien, only so much that it's based on what your building coverage and your building height is. We don't have FAR for residential, we don't have, I mean, I'd go so far as to just, you know, I know we don't like comparing other towns or whatever, but I would say, in Greenwich, if you're building a house greater than 150,000 cubic feet, you need a special permit. Now, 150,000 cubic feet is basically 5,000 square feet on 3 floors, 10 feet high. So just to give you a sense of what, you know, how other towns do regulate that sort of thing. But as long as we're on that topic, I would say, when we talk most of the time about setback variances, and we're saying, okay, 24.5 feet in lieu of the required 30. Well, we all know about what 5.5 feet is. It's, you know, this tall, right? You know, people have you know, a much easier time visualizing a horizontal distance from one point to another than you do trying to conceptualize volume or bulk. For instance, does anybody have any idea what the volume of this room is?
Oh, my God.
Yeah, but you know what it is, Mark? When you put a 2-story house next to a cape, it dwarfs it. Even if you're technically at the same line, reduced height, it just dwarfs it. I mean, this will change everything about how we rule on the homes on that street going forward.
But I think to that point though, Barb, there's a regulation that says they're allowed to do this.
Yes.
Right. So I guess that's what we have to default to.
If they were to
But-
tear
but
this
that's
house
the-
down, they could put some big
They
haunted
could.
house there.
They'd have to move it back in the
Yeah.
setback.
Yeah.
No, they can't.
They have to move it back.
They
have
could
to
move
change
it
the
back,
foundation.
but if they tore it down, they could put a huge house on that spot.
Okay, but Mike, what about the
but they
garage?
could put a big,
Why not?
tall.
I need to clarify, we as staff would not approve 2.5-story house, or whatever it is, at 24 feet or 24.5 feet, whether it's a replacement or addition, because we don't see
But
the
what about putting it
pronounced
back?
uniformity of structures, one
Well,
after the other.
I would argue that
So let's- we
Woody
would
doesn't
bring
see
it
the
to you.
pronounced
Say,
uniformity,
you're comfortable?
but
We're talking over.
I think across the street, there's
But
totally.
we're not talking about across the street. This is a
But this is
very.
the neighborhood.
No, this is a very clear regulation. It says if you look at the houses within 150 feet of this house, and if they're all in alignment, that's the new setback.
All right.
So the question is, do we think they're all in alignment?
Based on
I mean,
this,
there's
they
two
look like it.
bright red lines that are drawn on the
So wait a
map that
second.
make
So
it look
can you-
like they're in
can-
alignment.
Can you help me here? The existing residence is here?
yeah,
At
we're not,
30 feet?
the only footprint expansion is this little area
So,
right
so
here.
wait a second, so is your the existing residence is currently,
Out to here.
There's a photo of it.
The hatched area is what is second story volume in front of the setback.
so what's the gray area behind?
The gray area is what is getting expanded as a result of.
Just going up.
Of just going
The
up.
footprint is the same.
The footprint is the same, with the exception of the small bay in the back.
I get that, okay, so the,
But, okay, and then Mark, what about this garage? The garage is clearly not in the, so
Well,
you're
the garage,
proposing,
the existing garage that's there now is in poor condition, and it's in a non-conforming location.
Right.
So to offset, because we're at maximum coverage now, to offset the increase of the little kitchen bump out there, we're proposing to demolish the garage and build it a smaller garage in a conforming location for an accessory structure.
Okay.
The side yard setbacks, side and rear yard for an accessory structure in this zone is 5 feet.
okay, so that complies. Okay,
Yes.
got it. Well, at one point, the measurement says 4.5, but it looks like the
Well,
garage
that's
is
the
actually
existing.
5.1. Oh, got it,
That,
okay.
the 4.5, so.
So you're bringing that into compliance?
We're bringing that into compliance,
Okay.
yes. We're trying to work with everything, with what we have, and not turn, because as I said earlier, you reach some threshold where to modify all the structural elements of the building, it reaches a point where let's tear it down. And then it does raise the question of whether we could build a new, because I guess when we talked about new building, is that building the verb or building the noun? You know, and I think Woody said that. Well, what does that mean there? But would you want a new house set back 5.5 feet from where the current house is, and then be driving down the street and people are, well, why is this thing set back 5.5 feet more than all the other houses?
Yeah, okay.
All right, so you think it's pretty simple. It comes down to this 372. It's not about design, it's not about the mass and the space, because it lines up with every other house in the street.
The zoning regulations are what the zoning regulations are, and I don't want to get into deliberations as to where we are, but I mean,
Yeah, I
we're
think
still
we should-
bound by the zoning regulations,
so I
right?
think we understand the application.
We understand
so
the
I think we
application.
should-
Does anyone need to hear any further information about the variance application?
The hardships and the reason, I don't want to.
Okay, so I'll just because we got so involved, I was actually thinking the discussion of this section would be the smaller part of the presentation, and it turns out it's been the larger part. But, you know, again, going back to the item K, where I've enumerated changes to zoning regulations in the zone map, the non-conforming location of the home, the now non-conforming lot shape and area, and the architectural challenges that I mentioned by stepping back the 5.5 feet, and because of the center chimney, you end up with very little usable space, and whatever is usable will be awkward between that chimney and where that wall would be if you step it back 5.5 feet.
And I think it's interesting to point out, not to help your case, But what your client noted is that although, in response to my question about the buildable area, you're already maxed out at 19 plus something %. So you can't utilize more of the buildable area to achieve more habitable space.
Right, not without eliminating, because the space that we're getting would be about equal to one floor of additional space if the garage were eliminated.
Right.
But we can't do that for a number of reasons, and again, that's why we want to move the garage to a conforming location, okay? But there's no exterior access to the basement of this house. And we can't add a Bilko because that's going to count for
That'll throw
coverage.
you over.
So we can't, so we're kind of stuck between the proverbial rock and a hard place.
What are we doing
And
with,
with three young children? I mean, just bike storage.
What are we doing with
Utilities, yeah.
Thanks, Barb and I.
The
were-
mechanicals, that's our thing.
Well, at this point, there was no. You had Nick. I think we discussed that we were going to.
removing the 7-foot wood stairs that are on the driveway now to pick up coverage. We're reducing the garage when we bring it into the conforming 5x5 by 25 square feet to make it.
Well, I think what they're, not to interrupt you, but just to save them a little bit of time. So they're talking about, we had discussed certain things about, like the
Yep, and so
AC
AC
compressors.
and utilities, 9x9, we're gonna have AC and maybe propane, but those will be within that 19.8%. We're reducing enough of the garage so that when we add those, we're gonna be at 19.9.
Right, but even one, just to have one AC compressor wouldn't count anyway.
No, that's right. I was just wondering what
So-
else.
But they'll be within the setback.
Oh,
I'm assuming you're
yes,
putting
they
them in
would
the
be in a
greenhouse. They're just not
yes,
on
they
here.
would be in a conforming location.
Okay. All right, thank you. Any questions from the board? Woody? Anyone from the audience wish to be heard on this application? Okay, seeing nothing, we'll go ahead and close the application. Thank you very much for your time this evening.
Thank you.
Okay, well, that was exciting. We're finished, we're back now. As I said previously, we're going to do deliberations. If you want to converse, please try and keep it to a minimum so we can make it through. So the first application, calendar number 6, 2019, the solo application. I think they did a really good job in reducing their ask. I think taking the pool off the table was very smart, because I don't think it would have been granted, and it really makes our job a lot easier. I think that the proposed use, the change in the proposed use, unless I see someone that disagrees, I think they're keeping it within the volume that was already approved.
Maybe a fifth bedroom.
The fifth bedroom,
I
yep.
agree.
And then the third, and I'll go back and we can piece in hardships, but I think the third piece to their application is likely the most controversial. I agree with the sentiment that we have in the past seen applications for properties on more than one occasion, and we have granted, I don't know why I have so many copies of this map, and we have granted follow-on variances for those properties. So to me, the concept, Gary, I know it's a little troubling for you in that it's so near the time. But I guess the question is, why should that matter? I mean, if it's 6 months, I mean, is there a bright line rule? Is it 6 months? Is it a year? I mean, what's the?
I don't know, and I think that, I don't know, and I think that there has been great articulation of these, the principle, even in one of the cases that Wilder submitted to us, I think it was on a Park Lane, I think, but where the owner, I said that what they're asking for was a nice-to-have feature, not a minimal adjustment necessary. And I believe that the concept that I articulated in the minutes that were resubmitted to us, to refresh my recollection, I think, for me personally, that concept is the same. This is a nice-to-have, not a need-to-have on this property, especially since, and I get they kind of inherited this plan, and they inherited prior approval, but there are, again, it's a lot of, there's a lot of buildable area on this property. If this family grows and really needs a bonus room to make a 5,500 square foot house 6,000 square feet, I think they could find a way to do that.
See, Gary, I'm not sure we would have approved that bonus room the first time around.
I wasn't on it, so I don't know. And I agree that
We really
that's.
struggled with the volume of this house, the way it was set on the property. So, I mean, when he argued that, like, well, why are you not allowing this? You
Yeah.
approved it the first time. We didn't. This was
Yeah.
never presented to us.
And I wrote down, Wilder did say, if you would have approved it then, why wouldn't, you must approve it now. I don't
recall approving it then. I mean, I guess, what.
We don't know whether we would have.
We don't know if we would have, because they weren't filling out the house to the extent that they're now seeking. It was 2 people versus this larger family. So that's what I'm struggling with. We're talking about 43% outside of the buildable area. That's not the right word. It's just a lot
57,
more.
57.
That
So
did
that's
not
right.
come up first time around.
I'm troubled by it. I think it's a nice to have, not a minimal adjustment. I don't know. I don't know what I would have done if I were on the panel then and it was presented to us then.
I don't know. I mean, I think, families change, people change, plans change, ownerships change, and people have differing needs for the property. And when we talk about the required minimum adjustment, I don't necessarily think we're talking about the required minimum adjustment overall. I think it's as part of that application and what their hardship was when they presented it. And so to stick someone with, well, you didn't ask for this last time, so you can't ask for it again, is pretty.
No house would ever change.
Right, it's pretty draconian. To ponder whether we would have or wouldn't have, I think is fruitless, because it's in front of us now, and we need to decide what we would do now.
But I assume, and I haven't looked back to this, I assume when we stipulated, we didn't say no more, and we do sometimes.
We did not.
Ruth Ann, to your point, no one would ever apply. We often say, this is it.
We wouldn't be here.
Right, we did
No,
not
we
say
often
that.
say, this is it, we've maxed.
Yeah.
So,
Also, Gary, when we saw this initially at the first time, we also went and saw the property after it was demolished.
Yep.
And we saw the footprints, and at that stage, given what was proposed to us, it made sense because it was in compliance. Well, it had some variance, but it was in line with what we were thinking about. Then the subsequent construction issues came along, and that plan never got executed. I also agree with you the timing of the variance, but if the first plan was house was fully constructed, and if they had come for the variance, subsequent variance, that would have been a clear issue. But here, nothing got constructed, nothing came off the ground, and we are now just looking at the application with a fresh set of eyes, So that to me makes a difference. And having seen the property, the difference between the original variance and now is not significant in my view.
Meaning you don't feel that this revised application, and here's the.
significantly impacts the.
Significantly impact, yeah.
And here's what's interesting to me about the whole thing is, we will see people come back and ask for us to approve something like this without a public hearing.
No.
Amended plans, we've seen
wouldn't have-
3 or 4 of them where they came back with different, was that chimney was in a different place and the roof line was completely
We wouldn't
different?
have ever granted anything like this without an administrative.
Correct. I agree, but so they've come back to us.
And Gary, just to add one more point, they did make an adjustment to what they came to us last time.
Yeah,
So
no,
the change they made in the pool and some of the other features, I think they made an accommodation, that kind of fits.
And then also, I think that if you take all the houses that surround this house, they're pretty significant in size. I mean, it's not like,
It's in
they're gonna
keeping.
build this 5,000 square foot house next to a 2,000 square foot houses. It's tokenique, they've got big houses there.
I'm going to, like we did previously, rely on the previously found hardships. in determining that there are hardships on this property that warrant the granting of a variance. It's obvious because one's already been granted. Those hardships are outlined in the item K submitted by the applicant. So I'm going to make a motion to approve this application as presented. I think that it is the minimum adjustment necessary in light of this application. I did not sit on the previous application, so I can't decide whether I would have or wouldn't have approved it. And I'm not going to speculate on that because it doesn't really buy us any forward momentum. I will, the memo presented by Wilder, I think was beneficial and helpful in clarifying how we've acted. We know we're not bound by precedent, but we have, we have granted follow-on variances to applicants. Plans change, things change, and I think we have to be willing to work with the people in the town to help them as things change. So with all of that, I'm going to make a motion to approve as presented. Did we have any stipulations we wanted to put on this? Oh, we did. There would be a stipulation that no bathroom would be added to the new area over the garage.
Or a bedroom space. I think they agreed that it wouldn't become
Correct.
something other than a rec room, bonus room, whatever that is.
That's correct. That's correct. And any further applicant that wants to change that use would have to come back to this commission and seek a further variance to do that.
Okay, now excuse me, there's two parts. There's the extra volume, of course, over the garage, but there's also that other room to fill in the fifth bedroom.
Yes.
There's two remaining. The pool was, and the pool
The
equipment was dropped out.
Pool was dropped out and the pool equipment was dropped out.
There is one more thing.
Would it be fair to say that we don't really think the variance is needed for the conversion of the open space to a fifth bedroom?
Yeah, because there was no stipulation there previously that said that they
area's
couldn't
been
change it.
approved.
Right.
Okay.
That volume's been approved.
Yeah. I think
But if that's
consistent.
not sufficient, then we'll approve the changed use as well.
A or B?
I don't think, I don't think, you're not coming any closer, you're not increasing the volume, it is just a change.
Understand the point.
Change of use of air space versus bedroom space. So I don't know that we grant a variance for that. I think we should say it's permitted under a prior variance.
Yes.
Okay. Otherwise,
You could say we find that it's permitted under a prior variance.
Correct.
excuse me, I just thought of something. There was an extra variance that we didn't discuss tonight. I think it was brought up last time. This was an extra air conditioner, or maybe two, I don't recall. It was in a group of other air conditioners in the setback space on the club side. So,
Can it not be put in a conforming space? I wish we had discussed it. There's a lot of conforming locations on this property.
Did
you probably
the,
see it on the,
did the club, on the previous application, did the club have no problem with it? Even though it was not facing the club? Or on that club
Correct.
side?
the club has consistently supported the proposals.
Okay.
I think they had a group of 2 or 3 air conditioners, and they wanted to add a 4th or a 5th.
Yeah.
I'm not saying put it by the pool, but can't you put it there?
All 5 of them?
Or whatever additional one they're proposing with this application.
Just the one additional one?
5 compressors.
Then I think they're proposing 5.
That might be.
They're proposing 4.
There was a change in
It's
the
too bad you didn't bring that
application.
up while the hearing is
Yeah.
open.
I think we talked about that last, or at least was presented last time, but the,
So I'll make a stipulation that they will try and find a conforming location for those units.
try.
No, they either find it or not.
Yeah.
Yeah, I think the claim was with the extra bedrooms and bonus room. They needed more air conditioning capacity.
So look, if you're guys gonna give them the extra bedroom and the extra bonus room,
They're going to have to
put
find.
the air conditioner and that's being required by that additional use on this house, put the air conditioner in.
All right,
in a
stipulation that they have to
conforming
find a
location.
conforming location for the air conditioning units.
Otherwise, it's a cake and eat it too situation.
Okay. With those stipulations, I make a motion to approve the variance requests. Do I have a second? In favor?
What are you doing, Barb?
I'm struggling with the garage space, the bonus space. I really am. I think they've made enough accommodations. I'll approve it.
I will too. It's 5-0.
Yeah.
5-0, thank you.
But this is my last regularly scheduled board meeting.
Is this your last?
This will be my last, other than the special one.
Oh, I was going to say something for your last.
Yeah, well, I'm glad I stuck it in there.
Yeah.
I do think if we get challenged, we do have to be, and this isn't one that has challenged, I think we need to be very careful, because I do think the case law is suggesting personal preference, need to have versus want to have, or something that the board should continue to consider. And I do think, again, here, I think Dan, you're absolutely right. They did a very good job of reacting to our concerns last time and reduced their asks. And I think that's equally important to this board, and we should maintain that.
Make note of it, for sure.
Kind of maintain that consideration.
Great, and I love the design. I think it's good.
Thanks, Gary. Okay, so we're going to go ahead and move on to calendar number 8, 2019. Which one is this? This is, okay, this is Gallagher. Oh, this is, okay, this is the one we already saw before, so we read the record in. The hardship is whatever we found.
Yeah, I'll just make a motion that we approve again based upon the prior decision. And this was somewhat of a miss on a request. Had they asked for us to extend the time period while the variance was still valid, we clearly would have granted it.
Granted.
So I'll move, but
The only step is the town engineer reviewing those.
The drainage.
Drainage plan.
and just, it's based upon the applicant's representation that the drawings, that they're permitted to build what they submitted in their prior application.
Okay, I'll second that. All in favor? Okay. Calendar number 10, 2019. This is another one. I mean, I don't know. This was built.
Yeah.
It exists.
Hold on. It was built a long time ago, not by these people.
Right.
So it's not kind of the ask for
They haven't created
forgiveness
any
after
hardship.
they did it.
Right.
But when things come in front of us, we try and correct and make adjustments where we can. I would say in this case, I think the home is small, the use is appropriate, it's not outside of the realm. I think
Right.
they just stumbled upon a problem, they're trying to fix it, they're trying to make the house better. As a Realtor, I'm thrilled.
Right. So they have articulated a hardship, which is specific to this use, which is the change in the zoning regulations, the age of the structure, and the fact that this was already constructed presumably
More than 9 years ago.
more than 9 years ago. I don't see any stipulations to this. I make a motion to approve the,
Woody has an issue. What do you want
I just wanted to suggest that, just require that be proper permits obtained, and inspections, and a CO.
yeah.
Gotta clean it up.
For the repair,
Yeah, that's required.
That's a given though,
After
yeah.
your approval, they can do that.
That's how we arrived here. They were
That's
going
how
to pull
they
the
got
permits,
here.
which I love.
Well, it's important for safety, too.
That's fine.
Who knows?
Yep,
Okay.
yeah. So
I mean, they opened this can of worms on themselves, so they could have
Well,
just
because
not
because it leaked.
done it.
Do I have a
They tried to
second?
do it the right way.
Do I have a
Yeah,
second
yeah.
to my motion?
Yes.
Second,
All in favor? Thank you. Okay. The last one of the evening. All right, so this is an interesting one to me. I'm not, if this had come in as a variance application solely, a lot of the volume arguments, a lot of the, in relation to the neighborhood, the dormer arguments, I mean, all of that seems relevant. But to me, and I'm looking for advice and counsel here, because to me, it looks like there's a regulation that is 100% on point. I read it 2 or 3 times, Gary read it a couple times, and it basically says that because of the nature of this street, and because of the way it was laid out, they've effectively created their own front yard setback. And once they do that, it doesn't say anything about in keeping with the character of the other.
And each of these houses were permitted when they were built, and they were built there.
Yeah.
And so I was skeptical, as Mike was. Mike forced me to read the provision of the regulation, and I think it is clear. And I'm concerned about the extra the mass, but if effectively it's creating a 24.5-foot line, then it's effectively a 24.5-foot line, as if that were the setback in this zone.
Yep.
Which is crazy. I mean, kudos
I'll tell you,
to Mark for finding it.
I mean, as a realtor, what we don't like is to see, little Cape, bop, big store, we don't, the inconsistency, but there's nothing to say they can't do this. They're doing within their rights. The house
Because
design
of
is
this
beautiful.
regulation.
Because of that. As long as we have something to fall back on, then
They are also making it more conforming by taking care of the garage.
Yes.
I agree.
That's a good point.
And they were very aware of the maxing out the footprint. They didn't ask to expand the ground level, which I thought was conservative, so.
So I think they have a new front yard setback.
On the left side of Phillips Lane
Phillips Lane.
as you leave Hoyt.
Can't, I mean, it feels like I'm,
So 14 years, I've never seen this.
it feels like
It's
I'm-
actually been used on homes. There was an argument
Yeah.
that all the houses were set back further than the setback to try to prevent someone building as of right.
That's in there as well, though.
But he was allowed to build as of right.
I feel like we just saw this on Park as well, on Park Ave. Didn't we do something with Park where they
No,
were?
it was no more than 60.
The argument has been made before.
Yeah.
I think it
I
carries,
saw it in continuing ed.
I think it carries water. I mean, if the town doesn't want it, I guess the only thing I would say is
They change it.
planning and zoning needs to look at this as part of, Ruth Ann, hang on. Planning and zoning needs to look at this as part of their annual or however often they review the zoning regulations. But as it stands right now, I don't see any way we could, not enforce the zoning regulations as they're drafted. And yes, there's the argument that they're not in conformity, but I didn't even use marks. I used the assessor's map that he provided, and I put a straight line, and they are on the line, like they are right there.
Even across the street, it's.
So I'll make a motion that pursuant to section 372 of the Darien zoning code, that we permit the applicant that no variance is necessary, and that the applicant is permitted to build as proposed in accordance with the plans that were submitted.
An as of right kind of thing.
And one other comment, there's no mechanicals marked on the plans, but those would also fall within.
They all have to be conforming.
conforming, okay.
We're granting no variances.
Yeah.
No, exactly. Okay?
I'll second.
All in favor? Approved. Congratulations.
No, it's a good one.
Yeah.
Gary, I do want to say, while we're still here, and we're
not on
still
the
on,
record.
we're still on the TV, and I forgot to do it on the record, but I do want to thank you for your service, and you've done a great job. And Woody, I know, made a big push at the end to try and get you to change your mind and tug at your heartstrings a bit. We haven't been able to do that, unfortunately,
But I've met with who's the gentleman who's going to be recommended to the
And who is that?
Board of Selectmen. I can't tell you that.
Oh, that's
But he's been-
exciting.
But he's been recommended, he's good.
Will he be
smart.
like a permanent alternate like we are?
No, he's
Okay.
taking,
He's taking your
you
chair.
guys still may be busy, but he's taking the permanent seat. He's got town government experience. He's a lawyer.
Did you get a watch or a ring?
I
What
got
did you
nothing
get for
from Woody.
17 years of service?
I don't think it's 17, but I got
Get to
nothing.
hand him his nameplate.
I get my name.
Oh, you get your nameplate.
And
Do you
then
do that ceremoniously at the
And then
end?
during our holiday party.
You still get an invite?
As long as I get an invite to this year's holiday party.
You're definitely
Here,
getting
I've learned
invited.
so much under your tutelage.
I
Thank
was
you.
going-
Thank you
yeah,
very
I
much.
was
I'm
going
just a
to
phone
say the
call
same
away.
thing, Gary.
Thank you.
Thanks.
Learned a lot
I will
from
be
you
using
and,
that.
We may need to use
I
you as
agree.
a
The voice of
consultant.
reason.
Absolutely.
So,
Really very
I
good.
think in a year or two, I might be able to appear before you.
Well, you certainly know
Well,
we're
that
going
would be
over
exciting too.
with nothing further in the deliberations, Judy, you can head out, and we'll get into other business. Woody, what do you have for us this evening?
Well, the policy possibilities that we talked about a little bit, I have copies of
Did we?
the two we've been talking about, if you'd like to see them.
Sorry, I want to read a reg.
I just was curious.
No, well, we shouldn't discuss that.
Bring the book.
We've adjourned, or we've
No.
closed
Or
here.
just another.
Yeah.
So we have this potential policy regarding applicant contacts. We've been working on that for a few months, I guess. And the other one about correcting violations and encroachments. Do you have time to think about that or look at those?
I think in light of it being Gary's last hearing, we should adjourn
Quit now, quit now.
before 9 o'clock and let him get home to his
But I
family.
do think that, I think we've done historically, we've tried to fix encroachments and fixing violations that are blight violations, for example. I think that's not, I won't be here to rule on it, but I think there was, I forget what the road was next to Woodland Park. There was the guy came before a variance and he was clearly encroaching upon town land and maintaining it as his own.
Oh, yes.
In connection with the variance, we said you gotta move your fence back. That makes perfect sense to me.
Well, those are safety issues, those are zoning issues, and when we talked to Luizos about it, he's like, yeah, that's the type of stuff you should be correcting.
So I think that makes sense.
That's properly, but no, unfortunately, you know, and that's got to be dealt with, but we're the wrong venue.
I agree.
So,
For anything else?
all right.
How about this? Can I offer these two policies to Mr. Green for comment back to?
Before he leaves us?
Between now and June 30th.
Before he's finally
Yes.
gone?
Yes,
Between now and June 30th,
And he
I'd
can
be happy
report
to.
whenever he has a chance?
I
I'd
will,
be happy to do that.
That would be great.
I
That'd be
will
really
make a
helpful.
motion to adjourn.
I'll second.
All in favor?
All in favor?
Nice job, Mike, thanks.
Thanks, Gary.